Welcome everyone to Discovery, Hearings, Trials, and Appeals. This is for instructional purposes only, not advice as to any particular legal matter. Okay, you're like, Greg, this is what we do here every day. This is our blood and guts. This is who we are. This is our core: discovery, trials, hearings. And if we don't prevail, what do? Appeal. Thank you. Yeah, just keep yelling things out as we go through. I've made 2 changes to today's presentation, exactly 2 changes. And I'd just like to see the eagle-eyed people out there who notice what are the 2 changes, 2 legal references that changed in this iteration. We're going to talk a little bit about hearing types. We're going to talk a little bit about appeals. And again, I want us to think about appeals, tactical appeals, because they are tactical in this jurisdiction, and less often strategic appeals. We're trying to change the law. We're trying to change something. The last thing I want to talk about, because we do have, now we're over 70 people attending remotely, how do our clients know we're doing a good job? How should our clients be judging what we're doing from them when we're handling cases from them, when we're going through the discovery process, which we all know is a little bit limited in workers' compensation context? How does our client know they're being represented well? And how do we know we're representing our clients as strong advocates for them? So let's begin with discovery. Let's begin with the first part of discovery. And I want us to deep dive in our cases. I want us to spend the time and attention and all the blood and treasure that might take to make sure we're doing a really thorough review of the cases that come in. There is no limit. I don't want you to ever think, oh, I'm not going to go explore this potential vulnerability in opposing counsel's case because it's going to take too much time or effort. This is where we're doing our important work to make sure we're doing this stuff. So let's talk about, and I said there's going to be some changes in this presentation today. Here's the first one. Let's start with the claim itself, the employee claim form. Under Section 28 of the statute, the claimant must fill out a claim form, and they have to sign it. And it's such an important part. And I just want to gloss over that. In a lot of our cases, this is where we should start with when we get into e-case. We start looking at the file. What's in the employee claim form? What are they alleging? Remember, the judge can't establish a case if they don't file the claim form within the first 2 years. They have to do it. Don't let them get away with it. And if I was opposing counsel, I wouldn't want my client to sign an employee claim form. I'd want to keep it loose. I wouldn't want to be answering the tough questions that indicates, do they have a prior claim? That's the most important part of that. And to me, that's what I look for. I look for, hey, what are they claiming? What are the body parts they're alleging? Can we lock them into a mechanism of injury? How are they alleging they got injured? Are they saying it was a fall down? Are they saying it was a motor vehicle accident? What are they saying? And then that important part of that claim form on the second page, they have to say, did I ever injure this body part before? And again, it doesn't have to be injured in a workers' compensation context. It could be injured in any context. They've ever had any pre-existing conditions to the same body parts that they're now alleging are part of our workers' comp case. If they answer yes to that question, they have to tell us with whom. And that's your first step. I mean, that's the stuff that we should be looking into. That's some important discovery for us to start looking into. I don't think that's an adventure to go start establishing that in every case. I want to see, even if they say they didn't have a injury. Well, how are we going to test that, right? Because our job, our superpower is skepticism. Our superpower is to look at these cases and say, oh, you're telling me the sky is blue? That's cute. Prove it to me. How are you going to prove to me? And so the next thing is, how do we test the things that they put in their claim form? Well, the first step is we should be getting a Claims Index Bureau Insurance Services Organization report in every single case. Every case, even cases, by the way, that are referred here and the client says, oh, it's all settled, just please fill out the Section 32 paperwork. I'm still like, hey, could we make it sure that we're not paying for something that we don't have to pay for? That Claims Index Bureau report is gold. It is important. And we shouldn't just stop when we just get one of them in the beginning of our case, because these cases drag on for years sometimes. The Claims Index Bureau report should be renewed every 6 months or so. We should ask our client, please go and get another one of these things, and let's see if they have any prior identified claims that we can maybe attribute some disability towards. Now, I think this is a real advantage to us that we should not give up. For our clients, most of them have worked out a wonderful deal with the insurance services organization, and they only have to pay a very small amount of money for this report. It's quite efficient. It might be $10, it might be $12. It's not much per search. Now, opposing counsel do not have those wonderful agreements worked out with insurance services organization. And if you or I or a plaintiff's attorney who does not have a relationship with that organization called them up and said, hey, I want you to run an ISO on my client. Imagine if you were a claimant's attorney and you were trying to be diligent and make sure that there wasn't anything that was going to surprise you in the case. You'd want to run that report. Well, insurance services organization is going to charge them a couple $100s for that same report, which is the reason why no claimants counsel run these on their own clients. Maybe part of it is they want to keep their head in the sand and maybe not know about their client's own prior conditions or injuries, but also they don't want to spend the money. Now, I could tell you that in all of my years of practice, I've been at this for a couple decades now, 23 years I've been doing this. And in all of that time, I've only come across one opposing counsel, and her name is Joyce Parisi. She's a great practitioner, very effective attorney. In fact, when my mom had a workers' comp case, that's who I sent my mom to, okay? And she's the only attorney that I'm aware of as a plaintiff's attorney or a claimant's attorney who runs an ISO report on all of her own clients, okay? And why? Because she's worried that she's going to get surprised. Because when you find something good in that ISO report, that Claims Index Bureau report about the claimant, well, that's something that we know that opposing counsel doesn't know, right? That's going to give us an avenue for us to do investigation into the claimant. We're going to turn over those rocks. And what do you usually find when you turn over rocks? Like weird bugs and gross stuff, okay? So that's why we want to do this, and we want to encourage our clients to do it. Now, some clients will say, oh, I ran one a couple of months ago, it was clean. Say, okay, could you please share the report with me? I'd like to take a look at it. Why? Make sure it's the actual right person. People have common sounding names. As we're learning in the Unfolding RICO organization, you know, that we've got common names and we've got 20, 30 claimants all living at the same address. In one of our cases that we had, we ran an ISO report on the claimant, and it was interesting that the claimant came back with having a workers' compensation claim. It looks like one every other year. And because they also match by address, right? Because sometimes the names are common sound. They also tell us all the other claims that have emanated from that address. We discovered that her husband also had a workers' compensation claim, and it looks like every other year. And then actually they traded off. So you go back 10 years, it was every 1 year the wife would have a workers' comp claim, the next year the spouse had the workers' comp claim, and you look at it and you go, what a pattern, right? This is something I can work with. So don't give up on these. And even when they come back with information about other people who live at that same address, take a look at it, because you might discover there's an interesting pattern that's developing. Are these the two unluckiest spouses in the world, or are they ginning up false workers' compensation claims? Okay, so skepticism, turn over those rocks, take the time to look at these things and check them. Is this the right person? All right. All right. So now let's imagine that you've done these things. You've got the claim form and they've identified a prior, or you've got a claims index report that shows you, hey, maybe a prior. Take the moment to say, okay, is it the same body part? If so, I think you know what you're doing next. You're going to subpoena those records, right? You're going to obtain those records from those prior medical providers, or if you can't find a prior medical provider, you're going to go try to obtain those records maybe from the prior carrier. And if you can't find either of those, what do you do next? Can you subpoena their prior attorney who represented them? Yes. Can you subpoena the prior defense counsel? Yes, right? So maybe they have kept the records even if the carrier or the custodian of those records doesn't have them anymore. So you can go after that information. Now, that's going to be a signal, obviously, to opposing counsel. Hey, they've got something on my person, all right? I also want you to think more broadly about using subpoenas. Let's say they come back and on their employee claim form, they truthfully tell you, no, I've never had a prior claim involving the same body part. Let's say it's a shoulder. Okay, maybe that's the truth. Then you get a CIB report and it comes back, oh, they did have a prior shoulder, but it was the opposite shoulder. Guess what? I'm still going to want to subpoena those records. Why? Because you might have range of motion testing on the contralateral member, which is the body part that's involved in your case. So I would be very broad in using my subpoena power to go investigate claims, even if they're not exactly the same body part. Still look into that. There's another practice that I've seen develop here recently. I can't understand it. Paraprofessionals who are saying, oh, I gotta do all this investigation, and asking the client's permission to issue subpoenas. So I'm gonna look around this room. I see about 50 of you. We've got almost 90 people online watching. So I can't see their faces, but I can see yours. Do we ask our clients permission before we issue a subpoena? Okay, I see Christian nodding, going like this. Okay, take that as a good hint, guys, that no, we don't do that. Paraprofessionals, if your attorney says, hey, look at the CIB and subpoena all priors, that's the instruction. Go execute that, okay? Attorneys, if you're telling paraprofessionals, hey, let's go get all these subpoenas, just go do it. We don't need anybody else's permission. We don't need to go to the court. We don't need to do anything. Just go right after it, okay? That's something that we would pursue on our own, okay? That take your own initiative on that and do that investigation. Now, before I move on from subpoenas, what happens when the doctor's office doesn't respond to your subpoena? What do you do next? What are some options? How do you enforce the subpoena? Well, you could follow up with a scary letter, right? Because there is a scary letter you can send. Because under the relevant subpoena rules in this jurisdiction, if a doctor refuses to comply with a lawful request for their medical records, they might lose their authorization to treat workers' compensation patients. So there's a scary letter you can send them to follow up. What if you can't do that, or you don't want to do that, or you've tried that and it still didn't work? Well, you can go into workers' compensation court and ask the judge of compensation to issue a so ordered subpoena. In other words, the judge themselves instructing or commanding that medical provider or that custodian of records or that insurance carrier or that attorney to turn over the records to you, okay? How would you do that? Well, you could ask for it at a proceeding, or you can file an RFA-2, request for further action. And the action you're seeking is, Judge, I need a so ordered subpoena. They're not getting back to me, okay? Now, before I move on, the last thing I'm going to say is, let's say you've done your job and you've done it well, because I know you will. And you get this pile of records back from the party that you've subpoenaed. What do we do next? What happens with those records? Okay, I'm looking around, I'm seeing a lot of faces that are just pregnant with information, but I'll answer the question. Okay, one, we have to supply it to the opposing counsel, right? We're gonna file that with the board because that's our obligation, right? That's our legal obligation. But what are we gonna do? Well, we've gotta actually look at the results of our subpoenas, even if it's like 1,000 pages. Could you turn me down? I feel like I'm so loud, I'm gonna blast people's eardrums out here. Okay, we have to actually look at it. Okay, there's gold in there. There's might be great information in there. You know, we just won an appeal. Addison just brought it to my attention that Ryan Wallace wrote the appeal, and the appeal that we went through 1,000 pages of physical therapy records to demonstrate that there was a difference in condition, right? So I know it's frustrating to look at this stuff, and maybe someday in the future, 2026 and beyond, AI will help us with this process. But for now, we're looking at every one of those records. So let's not forget about our job, okay, which is to go through that stuff and find those nuggets. Find the things where the claimant's missing medical appointments because they're going on vacation, or they went water skiing, or they're mountain climbing, whatever they're up to, like whatever juicy nuggets that you can discover in there. Like, that's the moment for us to actually do something with the subpoena response. All right, let's move on to my favorite, covert surveillance. Covert surveillance. Today, we're defending about 4,500 cases in all 31 workers' compensation courts. How many of those cases do we have covert surveillance either obtained, requested, or in the process of being obtained? Anybody have a guess what percentage of the cases we have covert surveillance? No, wrong. Yes, sir. No, wrong. More like 25% of the cases we've got covert surveillance on. I got about 1,000 people at any one time that we've got surveillance coming in on. All right, now, I love surveillance. I love using it. It's one of those things that you can generate. This is something you can do. You don't need the other party's permission. You don't need the judge's permission. You don't need anybody's permission to get covert surveillance obtained, right? It's also something that we're going to generate. We don't have to turn it over to the other side. And it's just like a CIB index report. This is information that you have that they don't have. Now you know what their claimant looks like, how they're acting when they don't think they're being observed. I cannot stress enough how important the use of this surveillance is and the obtaining of it. And if you're sitting there and you're saying, hey, Greg, I think only about 5% of my cases I recommend or obtain surveillance, I think that's probably too low of a number. I don't think that only 5% of our cases do we have a question about the claimant's actual presentment and how they are portraying themselves. In other words, I think much more number of our cases involve potential concealment than 5%, okay? Is it more like 20 or 25%? Yes, in my experience, yes, I think that's probably the number. So again, we should be thoughtful about obtaining this. Next, and this comes up all the time. Okay, what happens when you say, hey, Your Honor, we got to put this down for testimony. I've got some covert surveillance. What do some of the judges say? What is one specific judge been yelling and screaming, and he carries on, and he's a little bit mean to us sometimes, Declan? Is that fair? And he says, oh, what's in your surveillance, counsel? I'm not setting this down for testimony. So you tell me what's in it. I go, no. Look at the rules and the regulations, right? 12 NYCRR 300.38 says we don't turn it over until they testify. And we don't have to give hints about what's in that, right? So even if the judge is screaming and yelling. Now, in this case, Declan and I were talking about today, the judge is a little bit, I would use the word strident, right? Oh, how dare you? I'm not setting this down for testimony unless you tell us what's going to be in that surveillance or what's in that covert information that you have. What do we do there? Oh, you're not setting it down? Let me put it on the record. I would say on the record, let the record reflect. I have surveillance. I want to take the testimony of the claimant. The judge is refusing to allow me to do that. Of course, the judge will say, well, blah, blah, blah. Okay, why did I do that? Because I'm setting myself up for a wonderful tactical appeal that I will prevail on 100% of the time. You will win that appeal 100% of the time. So where the judge tells you, no, you've got to turn over your report or tell us what's in the surveillance before I even set it down, you say, that's not what the rules say, Judge. Let's go on the record and let's make sure you say that out loud because I'm appealing it, and you will win 100% of the time. What did you also obtain while that happened? Suspension of benefits, indemnity benefits, okay? So the person's not getting paid and the judge made a mistake. This is a great opportunity. You can educate the court, you can stop payments, get some leverage in your case. What would I be doing next as soon as I walked out of that courtroom, or maybe even before? Maybe I would be texting opposing counsel. What am I doing next when I get the judge to say, I'm not setting this down for a hearing because you didn't can tell me what's in your covert investigation, Mr. Lois. What am I doing next? That's exactly right. Thank you, Christian, from the front, the only brave person beyond Brianna who wanted to sit up here. Yes, I'm immediately calling opposing counsel and being like, oh, guess what, silly heart? This is gonna go up for 6 months, and then they're gonna come down and they're gonna say, I get to take the testimony of your claimant and I don't have to show you what's in my surveillance report, right? Perfect opportunity for settlement, okay? I wouldn't wait for that appeal to wend its way through the board panel. I would be immediately turning it a perfect opportunity to settle your case. Actually, every opportunity is a perfect opportunity to settle your case, okay? How are you gonna present that? We're gonna present it with the investigators. Do we ever turn over surveillance reports? No, okay, we've got board panel decisions on this. We never have to turn over the surveillance reports. We're doing something better, Your Honor. I'm gonna present parole evidence. I'm gonna present the actual person who took the video, who's gonna authenticate the video. The video is gonna stand for what it says. It's a very simple cross-examination. Did you make the video? Did you edit the video? Did you delete the video? Did you change the video in any way? Is this a complete video? Thank you, I'm playing the video. That's it. That's your whole direct testimony. That's it. Then you sit down, you're done. Okay, then you play it into the record. The game's over, okay? Covert surveillance, this is something that's easy for us to win on. It's easy for us to obtain. You don't need anybody's permission. Next, non-covert investigation. Non-covert investigation. This is the things that these silly hearts are publishing themselves on social media about their own activities of daily living, okay? I know everyone in this room. I'm the oldest person in this room. I'm looking around. And even I post stuff on social media all the time. I'm sure you all do too. We're all under self-surveillance, okay? Two things, 2 points. Number one, you're an attorney or a paraprofessional. You work at LOIS Law Firm. You're defending a case. You're curious. You're curious. You Google up these people, right? We Google them up or Bing them. Jeremy, you like to Bing. I like to Google, okay? You're doing these things. And what comes up? These silly hearts drinking martinis, they're water skiing, they're doing all this stuff, right? I know maybe it's tempting to do what you would do with your friends, right? You'd screenshot it. Ha ha, got him. Okay. Please do not do that. If you're going to screenshot it, that's cute. That can't go anywhere. You can't take that screenshot, for example, and submit it to the board as evidence. Okay. I see you're blushing. Do you know what I'm talking about? We can't do this. Okay. It's tempting. I want to. We can't. Why? We just became a witness in the case. All right, you're attorneys and paraprofessionals, you're not witnesses. Please no. Now, if it's useful, you could say, look, I went on this, I saw this over here on Instagram. Look, their Facebook is public. Here's what's on it. Their kids' Facebook's public, and it's got pictures of them water skiing with them on vacation. Great. What do we do with that? We flip it forward to our adjuster and we say, please retain an investigator to do a social media canvas. Here's some starting points for you. Go get it. Go, please preserve this, okay? We are not witnesses in our cases. Even when you discover this glorious stuff, we can't utilize it ourselves. All right, what about when a co-employee, this is pretty common, this has happened to me, co-employees get annoyed. They go, this person's faking, this is a liar, Greg. They're concealing their true condition. Greg, I know this person's fine. Look, here's them on Facebook doing these things. And the co-employee sends you this information. That's great. They're the witness, okay? That's not a problem, right? So if you're getting it from another source, and the source, by the way, shouldn't be the examiner or the risk professional or the adjuster, right? Because we don't want our clients to be witnesses either. Again, if an adjuster says, hey, I did an open search and here's what I discovered, I'm so excited about this, go, this is great, please get an investigator to do a social media canvas. It'll be very cost efficient to do it, and you don't have to be the witness in your own case, all right? I'm looking around, I'm seeing a lot of nodding about this. I know we all do it. I mean, we're curious people, but we don't want to become witnesses. Don't capture that information and intend on introducing that in court, okay? That needs to come in through another party that would be responsible for that documentation. All right, next, depositions. I love depositions. Our adversaries hate depositions. Judges hate depositions. Judges hate everything but an NFA, right? Their goal is, can you do a 32, sir? Can we put this through? Can you stipulate to a TR? Can I NFA this case, right? That's their goal in life. Our goal in life is to get to the truth. Thank you. I didn't know what you were going to say there. Get to the billing sheets. I don't know what you were going to say, but the truth, okay, the truth. Depositions are one of the ways we test and we get to the truth. It's very important. Opposing counsel are always going to be resistant to depositions. The judge in your hearings is going to generally be resistant to setting cases down for trial and requesting depositions. Our job as an advocate is to be ferocious and overcome that, okay? To be an advocate means we're doing things that not everybody likes or wants us to do. We're not here to get pats on the back from opposing counsel. I'm not here to get high fives and go golfing with the judges. I'm here to represent my clients. That's who we serve, and we gotta be mindful about that. Now, we have a deposition process in place here, and I'm gonna get to objections in a second, because I wanna give you, that's one of my new noodles in here I just wanna share with everyone. We have a deposition process here that involves double subpoenaing medical witnesses. I do that on purpose. We do that with a control date. So if they miss one depo, we have them lined up for another one. Okay, our experience has been when the treating physician does not appear for the deposition and we go, okay, move to preclude. Let's close the case. There's no more any prima facie evidence. We just precluded all those records because this person refused to come in and testify. The judge 100% of the time is going to give them a second chance. They're going to say, okay, go back to the drawing board, do the whole thing over again. So this way, we've done it already. We've subpoenaed the doctor for 2 different dates, one date that we're actually getting them to agree to, and a control date, just so we make sure we don't lose control of this process. And by the way, by the time you get in front of the judge and you're going, Judge, I subpoenaed them to testify and depose, and they didn't appear, and the judge goes, well, give them another try. I go, I already did that, okay? And the judge should then, we should move to preclude. That, by the way, is an appealable issue if the judge doesn't preclude them for failing to attend. The treating physician is always going to have at least one get out of jail free pass. What's their get out of jail free pass going to be? I was called into an unexpected emergency. I'm like, really? Unlikely, but sure. I mean, maybe a fun thing to do would be to like subpoena their operating room reports for that day and see if they really were pulled into an emergency, or they were just having a really good day on the golf course and didn't want to go take that deposition, okay? All right, how do we cross-examine those treating physicians? Well, the first one is laying down a foundation. What's their specialty? You know, everyone has been through our pattern questions and been through our pattern training. Did they actually perform the exam? Did they have some other person perform the exam? With New York's telehealth rules, does the doctor have to be in the physical same building as the patient they're treating anymore? No, that's insane. Okay, that's crazy. But please find out, have they had any disciplinary proceedings? Is their license to practice medicine unencumbered? Have they ever been in trouble, right? Have they been, for example, a defendant in a malpractice case? Have they had their license suspended because they're a drug abuser? Find out information about them. And by the way, a good place to look is in our own system because we've deposed a lot of these doctors at the same time. And the last thing I'll mention is the doctor a named defendant in one of the many RICO cases that are now pending? In fact, there was one filed, I believe last week or this week. The Defense Association of New York just filed their own RICO case as well. So I think we're up to 7 pending RICO cases with over 40 medical defendants. If you look at last month or 2 months ago, when we talked about those RICO cases and we shared with everybody the list of all the defendants, is your doctor on that list? If so, you should be asking questions like, doctor, isn't it true that you're a defendant in a case that claims you are over-treating claimants on purpose to generate additional medical billing and defraud insurance companies? Please ask them that question. What's their response going to be? Anger? They used to pretend they didn't know that they were defendants in these cases. Now they're admitting they are. It'll certainly get opposing counsel to wake up and start paying attention to what you're doing. But let's start asking those questions. Cross-examining these doctors. All right, don't ask exact questions unless you know the answer. I think that's like law school 101 kind of stuff. I always, still to this day, 23 years into it, I write out my cross-examinations in advance. I always do this. And I'm always thinking, because in my cross-examinations, I want to point them to specific documents in the record that I'm going to examine them on, not their general recollection. I write down the board numbers of all the document numbers of the things that I'm going to cross-examine them with. I think that's the best practice. Maybe if you're Clarence Darrow or Abraham Lincoln, the 2 greatest attorneys in American history, you don't need to write out your cross-examination in advance, but I think it's best practice. I also would tell you that if you ever cover a case for another attorney and you've got to cover a depot and they've already wrote out the cross-examination for you, aren't you like, what a nice person. I'm going to buy them a beer the next time I see them. You are, right? Like, be that great colleague that we all want to have as a colleague, all right? I would also tell you, ask the most leading questions you possibly can. I've discovered that opposing counsel rarely object to leading questions, and a leading question is any question that suggests the answer in the form of the question. They rarely object. They rarely stop you, particularly once you get your momentum going. And it's a great way of moving quickly into the meat of the matter that you're trying to get to. One skill is knowing when to stop. Once you've got the doctor to say, like, no, I actually never performed that physical examination. Actually, I met them at their initial treatment, but these other records, those were done through my PA. I'm like, huh, cute. That's great. You know, that I have my next motion that I'm going to do. My movement is kind of telegraphed to me how I'm going to attack their credibility. Next, what is the credibility of the physician and what are they basing their opinion on? So much of the time, it's just based on whatever the claimant tells them their complaints are. Are claimants always truthful? No, it's really hard to be truthful when, you know, pretending to be injured or ill or infirm is getting you paid, right? So we have to challenge that. What observations did you make outside of your treatment exam room? What else do you know about them? What do you know about their job? The answer to this is going to be almost nothing, right? This is fertile ground. If you've done covert investigation to this person and you've got that, you know, sometimes we get that surveillance video back that stinks, that makes you sad inside. It's just like the person like walking up and down their driveway to grab like the junk mail from the mailbox, or they just sit on their front porch and they're smoking a cigarette while they scratch off their lottery tickets, and it's not good stuff, you know. They come out of their house, they get in the car and they drive away and you're like, that's it. Okay, but that's something, and that doctor hasn't seen it. So maybe there's something in there. Hey, are they able to get in a car? Are they able to sit for long periods of time? Are they able to walk up and down the block? Are they able to collect their own? You could ask them this stuff and just see what they say. You don't know what they're going to say. That's okay, because again, you're bringing in information that maybe they don't have. All right, objections. Objections should be used when we're doing a deposition, particularly when we're protecting a deposition. But I'm going to give you one to start off with, and here's one that maybe some of you aren't familiar with. In a controverted case, claimant's counsel is not allowed to direct the testimony of their own medical witness. They're not allowed to ask questions. Is it everyone's practice that when you're in a controverted case, a disputed case, they're trying to establish a new body part, they're trying to get a claim established? Do you let their doctor testify and be directed by their attorney? Everyone should be going like this. No. Okay, you have a perfect objection. It's in section 300.38 of the rules. That says, in a controverted case, opposing counsel is not allowed to do direct testimony of their own medicals. Okay, why? Because the medical records are prima facie evidence of anything contained therein. So in every controverted case you defend, which statistically in LOIS Law Firm is about 1 out of 3 cases, you should be saying, no, you don't have the right to ask any questions, counsel. After voir dire, you shut up. Okay, you can do some redirect after I complete my cross. Okay, and that gives them an opportunity to try to rehabilitate their witness. But we should be objecting to any direct questions after voir dire in a controverted case. Okay, that's best practice. That's in the rules. Okay, we can do that. Next, formed questions. Adversary, when they're deposing our physicians, I'm making a lot of objections as to the form of the question. Anything that presupposes any information or any new fact, I'm objecting to that. I'm objecting to anything that calls for speculation. That's the death of our IME. As soon as they get our IME doctor conjecturing on the stand, coming up with opinions on the stand, responding to the worst hypotheticals, our IME doctor is dead in the water. We're in trouble. Okay, a good IME doctor is clever enough to say, well, thank you for asking me that question, counsel, but I can't answer it. That's not part of my report. Okay, now what's a speculative question that's typically asked of our IME doctor? Okay, they'll start off nice. They'll start off like, hey, did you perform the physical exam? Yeah. And your findings are as recorded in your report? Yes, they are. Those are fair questions, right? Then they'll go into the next one. But did you know that after they had their IME examination with you, they were in so much pain, they couldn't walk for 2 days. They just had to lay down and writhe in agony, taking Tylenol and medically prescribed cannabis. Did you know that? That's a purely speculative question. It's literally a hypothetical posed to our physician. If our doctor starts answering those kinds of questions, we're lost. Okay, we want to hold our IME doctor to the 4 corners of their report. We don't want anything that's going to depart from what they've opined in writing. The stand is not the time for them to speculate. Okay, so you've got to protect against those questions. Any question that starts with like, well, doctor, if I told you that, or if you knew that, or no, the claimant says they can't even sit in a car. Are you aware? Stop. If that's not in their report, that wasn't in the direct questions that we asked them to answer, that's speculation. Stop it dead in its tracks, because it will destroy your case. It will undermine the credibility of your physician. All right. The rest of them are, standard evidence, year 1 law school objections, calls for a legal conclusion, relevance of the question, asked and answered. All right. So we talked about some of this discovery we're doing, and we talked about how on some level we have to bring our skepticism to work, we have to bring our creativity to work, and we have to actually dive into the information we receive. Now, for clients who are listening to this, I will tell you that none of that involves going on adventures, okay? This is not fishing expeditions. We're trying to use our experience and what we have in front of us and the pieces that are missing to try to draw out reasonable conclusions, all right? These are not adventures. So what I always tell clients and what I tell everybody here is if you're engaging in discovery, there should be a point or a goal that you're trying to achieve, all right? We're here to uncover a conflicting or contradictory medical fact. We're trying to uncover a concealment of a relevant fact, right? or we're trying to undermine whether the evidence is parole or not. One of those things, right? And that is a simple statement. We're never going on these discovery adventures just for the purpose of seeing what we find, turning over rocks because turning over rocks is fun, or worse, billing. Oh, this is easy billing. I'll just send out 1,000 subpoenas that no one's ever going to look at or no one's ever going to do anything with. That we should have a simple statement. And I always tell clients, I'll tell you guys, if we can't explain what the strategy is on a matchbook in one sentence, it's probably an adventure. You're probably going off in a strange direction. To me, it's when I am in office hours or we're in caps or we're talking about cases with an attorney and I'm doing a file review and they can't tell me in like one sentence what their goal is, I'm pretty sure they don't have a good coherent goal that they're going to achieve. So be thoughtful about this. It's either to undermine a fact that they're asserting, it's either to find or detect concealment, or it's to try to preclude some evidence which might otherwise be parole. Those are basically the three goals that we're trying to achieve in this discovery process. The last one I would say is, and you don't have to engage in discovery to do this, is to demonstrate some important fact that you have in your back pocket, like the coworker who has this amazing social media post from the person DJing at a party or fighting as a professional wrestler while they're claimed to be too disabled to work. Like that's the stuff, you don't have to go through discovery. You're getting that right from your own client. That's easy to generate and develop. All right, hearings and trials, hearings and trials. Before the hearing, what are we doing? Well, our practice here is to send a pre-hearing report to our client. What's our goal? Okay, we're supposed to be like Dumbledore. We're supposed to be predicting the future for clients. Pre-hearing reports should be short. It should be 4 or 5 sentences. Cases listed for, before, Judge so-and-so on this date. Here's what I'm going to try to accomplish for you. Also, semicolon, comma, could be, here's the terrible thing that could befall you in this hearing. Next, here's my actions. Here's what I'm going to do about it. Simple, straightforward. Pre-hearing reports are not book reports. Nobody gets extra credit for writing the world's longest pre-hearing report. In fact, I would tell you clients are very happy to get short ones. The future of your client, by the way, is they're sitting there in their Microsoft Outlook, and I don't think they're even reading our reports. I think they're having like Copilot summarize them into 3 sentences or something. So just be as concise and brief as you possibly can be in your pre-hearing report. Know what you're trying to accomplish. You know, are we trying to exclude body parts? Am I trying to challenge indemnity? Am I trying to get rid of unnecessary medical that's only going to prolong the case? Am I asking the judge to do to do something? Like those are the main goals that are happening in a pre-hearing experience. That's it, right? And then the last thing is I'm trying to leverage the other side into a settlement. I'm trying to get them to a place where they want to come to me and beg me for an opportunity to bring this case to a close because it's become such a torture to them and a burden and they don't want to handle it, all right? We always say, know your case, right? We got to dig deep. You know, we're not snorkeling, we're scuba diving, okay? We got to know our case well, everything. You got to go down and you got to find out where the buried treasure is in your case, and it's up to you to bring that out and talk about it loudly to the judge. When the judge says, hey, why are we here? Tell them, we're here, judge, because I filed an RFA seeking, or here's the relief I'm demanding. Your Honor, this is, I need you to help us with this. Be very quickly to explain that, right? Get it out on the record. Be able to explain why you are entitled to what you're demanding. Now, unfortunately, this will require often educating opposing counsel as to what their obligations are under the rules, and sometimes even educating the bench as to what the judge must do. You know, words mean things in this context. Inside the rules, some things say may, and sometimes it says shall, and sometimes it say must. Okay, judges must do certain things. They must set a case down. If you raise a controversy, they must do certain things. So we have to bring that out. Now, I know we're all fire-breathing, fierce litigators, but not all the time does it work, right? Sometimes we don't get what we're asking for. And is this sometimes more often than not? Yes. All right, that's okay. At LOIS Law Firm, you are never responsible for outcomes. You're not. There's too much that's outside of your control, right? As a litigator, you're not in charge of how safe is the workplace. How nice is the employer? How amicable are they with their employees? Okay. You're not in charge of how severe is their injury. You're not in charge of did they wear their safety equipment that day. You're not in charge of what terrible physician did their attorney send them to. You're not in charge of and not responsible for what attorney they retain that they discovered on a subway bench sign or advertisement, right? You can't control so much of what's in your case. I don't hold you responsible for that. I do hold you responsible for our practice patterns and our processes that we know work. We're just responsible for what we can control. And the only thing we can actually control in a workers' compensation case is ourselves. Everything else. Did the judge have their breakfast that day? Does the judge like us? Did the last Lois attorney make this judge write a 5-page notice of decision opinion and make this judge maybe predisposed not to like us? You can't control any of those things. You're not responsible for those things, all right? We are responsible, though, for executing our process, our playbook that we know works consistently. That's what works. All right, arguments didn't work, maybe. Okay, loudly explain our exception. Have to do this. Can't appeal unless we raise an exception. There's a place on the appeals form, I believe, Addison. I mean, you nod your head, I'm telling you, that says, where did you raise this objection? You have to say it. Is that fair? He's nodding, so okay. People just tend to nod at me and say, shut up, don't call on me anymore. But yeah, you have to do this. Okay, this is a real thing. I'm not making this up. Note your exception. Note your exception. When you come back from court and you order those minutes, I want to see the exceptions in the minutes, all right? Afterwards, we're going to tell the client, here's what happened. Now, sometimes you're saying, amazing work. We sabotaged their case. We pulled out that loose thread in their sweater and the whole thing just fell apart like just a house of cards. They were begging us. The judge threw them out of the courtroom. Okay, not often. Okay, not often. Don't expect that. Okay, that's a few times a year, not an every time. Most of the times we're telling the client, here's what happened, and here's what we're going to do next, right? Because typically the first time you deploy a tactic, it doesn't actually get you anywhere. You got to do things 2 or 3 times. You got to raise fraud once. Then you've got to challenge medical causation, or then you've got to raise a labor market attachment argument. You got to go through this litigation playbook a little bit. Tell the client what happened. Tell them what you're going to do next. Please, clear and concise as we can possibly be. Shorter equals better. Longer is not justifying your lengthy billing entry. You could have a billing entry for 5 hours and your post-hearing report might be 5 sentences, and maybe that's right. Okay, don't feel like you have to show your homework. Not important here. But sometimes we don't prevail, and when we don't prevail, we have another opportunity, another bite at the apple, and that is appeals. Think about appeals as you're setting your case up, right? Sometimes you're trying your case to win. Sometimes you're trying your case just to draw out judicial or opposing counsel's error so that you can file an appeal, get your tactical stay, and position yourself for a settlement. That's okay. That's a natural thing to do. That's fine. All right, post-hearing standards. Post-hearing report should tell the client, dear client, this is what happened in court, and here's an opportunity we have to an appeal, and you should give them your opinion as to whether the appeal will be successful or not. That's daunting. And please don't say 50-50. That's like, oh, really? Your legal knowledge is as useful as a quarter, a coin that I flip in the air and see which side it ends on. Please, no, right? Give them a sense. I think this has a high probability of success. I think this has no possibility of success, but I'm going to do it, or I recommend you do it anyway, because there's a tactical opportunity here for us to gain some leverage in our case, okay? But again, 50-50, no. John and I, John's much more discerning than I am. He tries to give, he'll give a percentage, 53.7% chance of prevailing on appeal. I'm a bit more of a cowboy. I think it's either it's a yeah or it's a no, it's not going to prevail. Use your judgment, use your experience. You're not sure if it's going to be useful or not. Okay, we're not sure. What could we do? What's another advantage you have here at Lois Law Firm with 56 attorneys, including a former judge of workers' compensation that are your colleagues? Yeah, I would bring it to an office hour and be like, hey, what do you think? This is what happened. This is the results I got. I mean, that's the point of having partners, right? That's the point of having colleagues. Ask somebody else. But again, 50-50, that's not good. All right, what's our appeal path? Almost done, promise. First path of appeal is to the board panel. That's where most of our appeals go. Why? Why do we like those appeals? Well, there's a tactical advantage to those appeals. Our second level of appeal is either to the full board or the appellate division. As we know, appellate division appeals are costly, complicated. They use special paper, okay? There's binding involved. It's a whole thing, right? And ultimately, Addison might be having to drive up. Where'd you have to drive up to? Syracuse, Albany, Rochester? Ugh. Okay, no, not in winter. You did that in February, right? March. Ugh. No, nobody wants to be in Rochester, and the city should be closed. All right. And then the last course is to the Court of Appeals, which is New York's highest court. All right. The automatic stay applies at the first level of appeal. This is why it's tactical. This is why sometimes you're going to take appeals that you think have a low probability of ultimate success on the merits. You're going to take that appeal because you need some time, and you need to use time as leverage on opposing counsel. So when you're thinking about, hey, should I appeal? Think to your first level appeal, because you're getting that stay. That's a tactical appeal. It's going to take 5 or 6 months to get a reply back or to get some new direction in your case. While that appeal is pending, we should be working opposing counsel. This is our job. We should be trying to settle that case. Most of our clients would much rather have a settled case than a high probability of win on appeal. It's just more valuable because it's a closure, okay? It's a closure. Statistically, we'll tell you that about 1/3 of the time, about 30% of the time, a board panel does reverse the opinion of the workers' compensation law judge. Why is that? 2 reasons. 1, we are excellent litigators. We really are. Number 2, there's just a high amount of judicial error in the cases that we defend at the trial level. And what's really challenging, particularly for a less experienced practitioner, is the judge will seem very certain that they're making the right ruling. They might even admonish you. Might even say something like, "Oh, you're another Lois attorney who's raising this issue again. Oh, I always rule against you guys. Sorry, I'm not going to give you this one." Okay, that's cute. They're confident. We're confident. Okay, don't just because some of the other party seems real confident, the judge feels they have a high turnover rate. Now, to compare the reversal rate in New York, which is high, 30% is high, guys, to the reversal rate in New Jersey. Our reversal rate in New Jersey on appeal is less than 1%. 1%, okay? It's a smaller caseload. There's a lot of reasons for that, but this is a high percentage. So just thinking, maybe you're trying the case not to win the case, but maybe to get an appealable issue. That's fine. The other levels of appeal, because you're not getting that stay, I want you to be thoughtful and say, hey, there has to be a strategic purpose in general behind making this appeal, okay? But behind making that appeal. I think I'm going to ultimately win on the merits, the substantive merits of the case. Otherwise, it's just throwing good money after bad. I'll also tell you that sometimes when you lose, your feelings are hurt, right? And you say, I want to appeal this, I'm going to prove. This is where we need to take a break, pour yourself a glass of bourbon, enjoy some professional detachment, and just be mindful. Are we appealing for a good reason, a strategic reason where this case is really going to get overturned, where the case law is really favorable and was misapplied? Be mindful about that. All right, you're not sure if you should recommend a second level of appeal to the client. What would I do? Again, I would turn to my colleagues. 56 attorneys in this room, all practicing the exact same kind of law. This is incredibly rare, all before the same board and workers' compensation judges. You've got 1,000 years, literally, of experience in this room on just handling this kind of cases. I would ask somebody else. That's what office hours are for. All right. Some practical takeaways. First, prepare every case here like it's going to trial. The rare exception to that is going to be your settled Section 32 case that comes in 32. Don't think to yourself, oh, this is a simple one. I'm not going to really pay much attention. I'm going to deprioritize it. I'm not going to do a deep dive into my case. No, though every case deserves a thorough review. Look at the facts, look at all the medicals, think about what discovery you need to obtain. Next, the other side has discovery obligations. They have to return to us HIPAA releases, for example. Right? They have to provide us with an employee claim form. They have to. Or the judge has to discontinue the case because a case cannot be established without one. It's in the statute, Section 28. Demand that from them. It's not, it's something we should be demanding from them at every hearing. Think about your role as helping guide our clients through this horrifying process that they've become enmeshed in. This, at best, indifferent court system that doesn't care about their due process rights. You want to give your client actionable, specific, concrete, simple advice that they can understand. That's our job. These are not complicated cases. I know they can have complicated fact patterns. They can have complicated who's the right employer. There could be complicated issues of policy, what insurance policy applies, for example, in an OSIP context. But in reality, our action plan should be very simple and easy to explain. Matchbook, one sentence. This is where I'm driving this case forward. Focus, focus, focus. If it takes time, I believe it does take a lot of time and attention to focus a case, right? It's easy to be like a squirrel and just be running around like crazy and being worried about every little thing. But the actual value you bring, the value that will never be replaced by AI, for example, your judgment, your determination that, hey, this is the highest leverage opportunity in this case. This is my opportunity to create chaos for this claimant. This is their biggest vulnerability in this case, and driving the case towards that. That's what you actually do. That's your actual real job. Your real job is not writing reports or billing time or reading medical. Your actual job is that deciding, that judgment that will never be replaced. That's the most important and valuable thing that you bring for your clients. Don't give up on that. These cases are not chess matches. This isn't Rubik's Cubes that we're solving. These are Jenga matches. We're just looking for what's their weak point today, right? We're playing tennis with them. We're volleying back and forth. We're trying to hit the ball where they're not, right? That's the way to think of these cases. They are not puzzles to be solved. They are not puzzles to be solved, okay? They are a game that we are playing, and we're trying to position the other side. We're trying to do things tactically to get them to come to the table. All right, so be thoughtful about those things. All right, that's all the time we have today. Thank you everyone for joining us. Clients, you are welcome to see our newsletter. I strongly recommend Christian Ceson's podcast. Excellent. His guest last month was Addison. Excellent podcast. I listened to that. Thank you everyone. Have a great day.